case briefs, and so much more. LSData's got what you're looking for.
In 1964, the United States Supreme Court heard the case of Lucas v. 44th General Assembly of Colorado, which focused on the idea that all citizens are entitled to equal protection under the law, and the apportionment of seats in the legislature must provide equal representation to all residents. The case was sparked by the district court's finding that the existing apportionment of seats in the Colorado Legislature was unfair due to varying population sizes in different districts. The court put the existing system on hold until after the election, and a revised system was approved. However, some districts still remained with unequal representation. Plaintiffs, including voters, taxpayers, and residents of the Denver metropolitan area, filed suit seeking a valid apportionment plan for the 1962 election, while defendants included various officials responsible for state elections. Supporters of the current apportionment plan also intervened in the case. The Colorado Supreme Court ruled that neither the existing plan nor the revised plan was constitutional under the Equal Protection Clause, sending the case back to the lower court. The United States Supreme Court directed the district court to determine the validity of the apportionment scheme for the 1964 elections and ruled that both houses must be substantially apportioned on population. It found that the current statutory scheme, Amendment No. 7, and the modified senatorial scheme were unconstitutional under the Equal Protection Clause due to perpetuating disparities in representation.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.